Just believe us, we trying to teach you the rights to read you. It's just procedure, baby.
Trials, instruction, procedure. AWS gon' teach ya. Trials, instruction, procedure. AWS gon' teach ya. Here's a tip, don't get it twisted.
Welcome to Attorneys with Swag, the show you come to watch to learn about the law. I'm your host, Eugene Toussaint, and I have my co-host, Jack Gomez. And we have a very special guest today. Very special. Named Super Lawyer, 3 years, 3-peat, 2022, 2023, 2024. This is an honor reserved for top 5% civil rights lawyers, top 5% civil rights lawyers in the country. Named top 40 under 40 by the National Black Lawyers Association this year, right?
Yeah, this year.
This year, and also was of counsel on the historic case against the NYPD and their abuse against protesters during the George Floyd movement. And that's Masai Lord. Say hello to the audience.
Hey, what's up? Happy to be here. Hopefully we can have a good talk, learn about some things.
Exactly.
That's some knowledge off, you know.
Yeah, we're here.
Yeah.
Thank you for your service.
I'm glad somebody say that. You know what I mean? It's like after constitutional rights, like what did this do, like?
And today what we're going to be discussing is civil rights litigation. These are cases, police brutality, wrongful arrest, all those type of cases we're going to be discussing with Masai. So Masai, tell the audience about your practice and give them a little introduction of everything.
I started out as a public defender, class 2014.
Yeah, 2014
in
the building
in Brooklyn. It was a great experience. You know, I was able to handle thousands of cases, and really I was able to make a difference in people's lives. But I got an opportunity to do civil rights. I was going to do civil rights. It was something I was interested in. I didn't really know too much about it going in. But, I had a real good background in criminal defense, and, I had a lot of success. I was, doing a lot of amazing things. Just, I know it doesn't sound humble, but I'm just keeping it 100. So, this is what it is, right?
I was making on my
Yeah. So, what ends up happening is that, my friend, we decided to start a firm together. We've been doing civil rights litigation since then.
Shout out to Abe.
Yeah, run up Abe. So basically, I've been doing it for the last 6 years and what is civil rights litigation? Basically, anytime your rights are violated by someone operating under color of law. That means someone who's operating, a police officer in uniform, a police officer, off duty if they're enforcing the law, right? It's a little tricky. We're talking about that a little bit. Any type of state or local law enforcement agency, federal law, even though it's a little tricky. We'll talk about that too. So
even like military police and stuff like that? Or
no.
Okay. So is that a state level?
State and federal level technically.
Okay.
So with military police, you could say if they're operating under color of law, military police don't really operate with citizens normally. Mm-hmm. So you're not going to get a lot of military police cases. But there's a different set of laws for federal law enforcement officers, a different set of laws for state and local law enforcement officers. Okay. And the Supreme Court has made that big distinction. And basically, the practical application is that, I can't really take any federal law enforcement cases because they destroyed the law that way.
Right.
They destroyed the law, federal law enforcement.
Okay.
So if you get hit by the FBI,
I'll holler at you. Can I help you make that?
Enjoy the ride.
It's wild. I wish there's something I could do, but the law, they just destroyed the law. That was a couple of years ago, so they don't need to be paying attention. But a couple of years ago, they destroyed the law. So basically, they make it so difficult.
Mm-hmm.
All right.
Yeah, and so basically.
So let's start with just lay out the common type of things that you're gonna put in your complaint. You're accusing them of police brutality, wrongful arrest.
Basically, it's going to be false arrest, which means that you were arrested, you were detained in police custody, and false arrest goes from the time you're in handcuffs or not free to leave, depending on how the officer conducted himself, and then up to when you see the judge. So let me say this again: false arrest is up to when you see the judge.
Okay.
After you see the judge, it's called malicious prosecution.
Oh, okay.
All right, and malicious prosecution is a different standard than false arrest. So if you get arrested, say you spent 2 weeks in jail, that first 24 hours or 48 hours until you saw the judge is a false arrest claim. The rest of that time, from that 48 hours to the 2 weeks, is going to be a malicious prosecution claim. And those are two separate claims, right?
Okay.
Now, you have another claim that you have a lot, obviously, is excessive force. right? And in New York, the state law claim is assault and battery. And in federal law, it's excessive force. So that means obviously an officer did not use reasonable force to subdue you. Now again, under certain circumstances, an officer is able to use force. It's really analyzed pursuant to the facts of the incident. So it's really case specific. But if officer used excessive force, then generally that you can do any claim for that. There's another claim called failure to intervene, which means that if an officer is seen a constitutional violation, they have a duty to intervene and to stop it. And of course, they never do.
Right.
I would imagine they never do.
Yeah.
So you could,
That blue line is thick.
so you could bring a claim against the other officers who were standing around and watching while they ask. Yeah, and then there's some due process claims. Just quick rundown, a couple of them. A cop fabricates evidence, he lies about something, forces it to the DA, in trouble. Brady, he knows, oh, this, if I get this fact out, he didn't do the crime. Someone told me that he wasn't even there. I don't forward that to the district attorney. I just keep that secret. You can get him for a Brady violation.
Okay.
And those are the two main due process violations. There's a couple of other
Planting
ones.
evidence falls under those two?
Huh?
Because I've seen
Planting
situations
evidence.
planting evidence.
That would be fabrication.
Okay.
You're fabricating evidence. You're putting something there that wasn't there.
Mm-hmm.
So you're lying and you forward that lie to the district attorney. Or the district attorney finds out about the lie and uses it. I'm adding that last part because it's important because the district attorney has to find out about this and know about this in order for it to be a violation. If you violate it and then you never finds out and it has no impact on your prosecution, they're probably not going to, it's probably not going to be a claim.
Okay.
Now, these cases, they all start post resolution of a criminal case.
They can and they can't. So
Okay.
Generally they're going to. I'm just going to be honest. They're going to. But the thing about false arrest claims is that it doesn't matter whether you committed the crime with false arrest claims. And so you could, even though lawyers are going to take the case, I don't want to get you the wrong case, but you could technically be convicted of a crime and still have a false arrest claim. Because the only thing that matters with false arrest is what the officer knew at the time of your arrest. If the officer did not have enough information for it to be probable cause, then that means that you have a claim. Even if ultimately
You're the one who did it.
he found enough information later.
Like the cop got lucky.
So
Yeah.
that's interesting. So then, the legality of the arrest always comes up at a suppression hearing on the criminal side.
Yeah.
If a client wins their suppression, meaning there was something illegal about the circumstances of the search, which kind of nullifies the arrest, right? Because if you illegally got probable cause through an illegal search, would that equate to a false arrest then?
That's a great question. So when you're talking about the fruit of the poisonous tree doctrine, right?
Yes.
And that means that if you do an illegal search, anything that's recovered pursuant to that search has to be suppressed, right? Because the search was poison, and that's fruit of the poisonous tree. But this is a big distinction, right? Federal law, it doesn't matter. State law, it does.
Okay.
So under federal law, the Supreme Court said, look, we don't care about all this, whether the search was bad. We don't care about anything like that. The only thing we care about was you had the drugs on you.
Right.
So if you had the drugs, you got no civil rights claim. Doesn't matter if the search was bad or anything like that. Now, in New York State, it does matter. So in New York State, if you want to say, hey, look, it was a bad search, therefore they have probable cause for arrest, state will say, okay, you can have that claim. And I know someone recently, a friend of mine, he got $300,000 settlement on a case that's dead on arrival in federal court. Right, because he was able to do the state court claims. And maybe we'll just talk about the claims for 1 second. Just like a background, like how the claims work. So I'm trying. This is a little technical. I'm trying not to make it too technical, right? Quick, a little bit of history, right? So in 1871, we're going back, right? It's 1871.
Right.
It's during Reconstruction. The KKK is running rampant throughout the South, and they're killing black people and murdering them, slaughtering them, and they're depriving them of their constitutional rights. And back then, you had no way to bring a claim in federal court and you can't bring it in state court because the KKK runs a state court.
Right.
right? So I mean, that's their territory. And you're not. If you get in, you don't have the jury. The jury's going to nullify anything. You don't have the judges. You don't have the legislatures. You know what I'm saying? So you got no recourse. So the 1871 Civil Rights Act, what that does is that says you have a federal right to sue in federal court for a constitutional right violation. That's the first time that happened. Okay, so that's the history of why you can sue in federal court. But that means that federal court has its own separate set of laws than the state court. So each state is going to have the civil rights laws that are going to be based on what they call common law, which is the old English law that was carried over from Britain when the United States was formed. So they all have different variations in it, and then the federal law is realistically has about a little variation too. So the 12 different circuits of federal court, and each circuit has a little bit different, courts that they do. And the Supreme Court is
liberal circuits.
Yeah, liberal circuits. You got the conservative circuits. So that makes a big difference.
And when you're saying circuits, you mean like the state, or the area?
Yeah. So federal courts are divided into 12 geographical areas.
Okay.
In the country, and it's so in New York right now we're in the Second Circuit. In Philadelphia, where I'm from, shout out to Philly, it's the Third Circuit, right? So it's basically Texas is the Fifth Circuit, California is the Ninth Circuit. So that means that all these different circuits, they all have their own set of laws a little bit. And they're supposed to match, but the reality is the Supreme Court doesn't take up these cases a lot, so it's not going to match.
Yeah, so basically what happens is, and it's the same thing in state court to a certain degree, where that basically these circuits are going to develop like law over time. And those laws, if they don't make it to the Supreme Court, it will control how cases get handled in that circuit. Because they will have made decisions that if those decisions are appealed to the Supreme Court decides to take it, it won't be applicable to all the circuits. It'll just be in this circuit, this is what they do based on this decision from the circuit.
Now you may hear that, you can say, well, what happens when Circuit A says one thing and Circuit B says another thing? Well, technically, the Supreme Court is supposed to decide that, but the Supreme Court's not going to decide that. Why? They only take 50, 70 cases a year. Yeah, most of the cases are they're gonna take an abortion case every year, right? So regardless of what anybody feels about it,
they got 49 cases.
They say it, right? You gotta say that for the abortion.
No matter, no issue, nothing's on the table. Right. We just gonna take an abortion case because we just gonna keep trying to tear it down. So so they got their own political stuff they care about.
Right.
So there's 50,000 cases that the Court of Appeal, the whole circuit Court of Appeals decide. So you're gonna go from 40, 50,000 to 50 or 60. So realistically, what happens is that if it's in the Court of Appeals, they kind of make their own law. They're only really going to be reviewed once every 10, 15, 20 years. And so, and that's not going to help you out.
So are there certain circuits and even some states in which getting a successful civil rights case is dramatically harder than, let's say, a liberal circuit?
Yeah, so you have the worst circuit in the country is considered the Fifth Circuit. I think that's Texas and Florida. And then,
how's it Texas and Florida close to each other?
I'm thinking circuits like
wires,
right? Yeah. How are you going from one state to another? How do those two states become one
the Fifth Circuit? I think it's Florida. Let me double check that.
Yeah.
But they're just wild. They're wild. Yeah, they just do whatever they want
and get away with it.
Sometimes they do, sometimes they don't. The issue is that they're wild. They just kind of the qualified immunity is everything.
Right.
It's everything. It's really difficult. It's tough, and that's crazy because you're talking about 40 million people, something like that in that area. That if you have the Ninth Circuit, California obviously is considered pretty good, right? Second Circuit, Third Circuit considered pretty good. So, which is New York, So the reality is that the amount of rights you have depends on where you live. And if you live in a blue area, you get more rights, and if you live in a red area, you get less rights. And I don't know why people don't tell you this, but it's the truth. That's just the way it works. So, if I'm in, and again, you're a lawyer, so you gotta look at cases. So if I'm in Texas, I'm doing that case fine tooth comb. If I'm in If I'm in New York, I'm like, all right, you know, maybe I'll take a risk with it. But I'm not taking a risk in Texas. I'm just going to waste money. You know, it's a type of thing like, yeah, you know, you got to know you're in a bad district, you got some judges that are just, like, you're not up here, you know, not to get my mess up me and be like, oh, besides some of the judges. No, y'all good. I'm just saying that.
Listen, we're through experience. You're like, this guy, I don't know, man. You know? Last time I was here, you didn't offer me water when I went out, so it doesn't seem like that, you know, that being nice to me.
Yeah, I got a good track record, you know, in getting motions and winning motions. And part of that is just understanding how to frame arguments, right? Because it's like, if you say it one way, you lose. If you say it another way, you win. And you gotta say it the right way. It's not really a fact thing. It's like how you interpret it, right? Was a cop, like, I should be like, okay, was a cop like negligent? Did he just make a mistake? Or did he intentionally do it because he was trying to like hurt my client? One, case gets thrown out. Two, case keeps going, right?
Right.
So you have to make sure, like, I gotta plead this in a way. Some lawyers aren't comfortable with that. They're not comfortable saying cops lied, cops, you know, they're not telling the truth. So, you know, their cases get thrown out. I'm here to win, so I'm not worried about that stuff.
Okay, so let's start from the beginning. Like, a client walks through the door. What questions are you asking? How are you determining a good case against a bad case? Like, how do you get these cases to begin?
Yeah, definitely. So, I mean, how I get a case, you know, people hear about me, you know, get referrals, they get on the website, they go, you know, they see an ad in Google, whatever the case may be, to give me a call. So I teach people, you know, how to kind of evaluate and look at cases. In terms of civil rights cases, I guess the thing we don't talk about a lot is color of law, but that's a big deal, right? So the police officer has to be acting as a police officer, right? I don't know if you remember, there's this case of Amber Geiger who got off duty and killed Botham Jean in his apartment, right? It was an issue. Well, she wasn't on duty, so the case, you know.
So now that's like a civil thing.
It's a regular.
It's like a regular person versus
Yeah,
regular person.
it's not a civil rights case, right? Because she wasn't on duty,
Mm-hmm.
right? They try to get some creative arguments, you know, shout out to them, but you know, it's a tough sell, especially in Texas.
Mm-hmm.
So, you know, you got to be on duty. What about if you go to a store and if the store security officer is following you around doing some stuff and you get in a little fight? Nah, it's not usually that's not going to work. That's a store security. They're not acting under, you know, color of law. They're not acting as authority to the, you know, state or federal agents, or state or local agencies. They're just, you know, acting to the shop. So you can sue them, but it's that stuff too, because you get 1 year to sue them, where you get 3 years if it's a civil rights violations. So you got any intentional tort, you got to sue them within 1 year. A lot of people may wait, delay. You know, you got to get on top of that right away.
And there's also, I know when you're suing the city, even before you file a lawsuit, you have to put a notice of claim.
Yeah, notice of claim is something that if you have to file within 90 days. So basically, this is the way it works, right? The state and the city can make their own laws in terms of how you sue them. So they make it as difficult as possible.
Of course.
So basically, if you want, and these are state claims. Remember, federal lawsuit, I can just bring a lawsuit anytime within 3 years. If I want to bring a state claims, right? I have to file a notice of claim within 90 days of the incident. And then after that, if I don't file within 90 days of the incident, then most of the time I won't be able to bring a case. Then I have to file a lawsuit within 1 year and 90 days of what took place. So let's say you get arrested January 4th, you're going to have to 30 January, February, April 4th, you got to bring a notice of claim in. And you can file a claim, say you have a January 4th, 2024, April 4th, 2025, you have to file a lawsuit.
Now, what happens if they're arrested and that case is actually going through the criminal justice system?
Then you can file a notice of claim within 90 days of dismissal.
Okay.
So the way it would work, I'm sorry, this is technical. I don't know how to explain it.
We just got to get technical.
So you would have a federal false arrest claim. You would not have a state false arrest claim, but you would have a state malicious prosecution claim.
And why wouldn't you have a false arrest claim?
Because you didn't give the notice within 90 days of the false arrest, but you got 90 days of the dismissal. which means you have a false arrest claim, a malicious prosecution claim. So malicious prosecution and false arrest, two are the big differences. So like I said earlier, false arrest doesn't matter whether you committed the crime. It does matter for malicious prosecution. You need what they call a favorable termination.
And what's considered?
So the law got a little bit better. Back in the day, ACDs was a little questionable, but now anything that results in dismissal is a favorable termination. So your cause of action, your case, the statute of limitations starts running, the clock starts ticking the moment the case is dismissed from malicious prosecution.
Now, let's say, for example, you get charged with a bunch of felonies, right? And they dismiss those counts for you to take a discount. Does that count or no?
So, good question. So the Supreme Court just came down and confirmed this. This law in the Second Circuit, like I said recently, I think it was the Sixth Circuit, basically said that if you are convicted of any crime, you have no malicious prosecution claim. Now, the law in New York was that you have malicious prosecution for each charge. So say I'm charged with attempted murder, and I plead to disorderly conduct. Now, I can say, okay, you had probable cause for disorderly conduct. But what about attempted murder? I spent 6 months in jail. And you can make the argument, look, I wouldn't have spent 6 months in jail for disorderly conduct. Why? Because max was 15 anyway. So I can bring a claim for it on that attempted murder charge. And one charge, there was no malicious prosecution, right? There was a malicious prosecution, like I have a claim. Now, again, that circuit said, no, you get convicted of disorderly conduct, you're done. Even your attempted murder claim, you got nothing.
Okay.
The Supreme Court just, I would say, affirmed, reinforced, said yes to the idea that it goes to each charge. So to answer your question is that if you got disorderly conduct, yeah, probably up to 15 days of your thing is gone. But the rest of it is if you spend over 15 days, really 10 days,
They get a discount, but you still got a case.
Yeah, you still got a case. And a lot of lawyers don't know that either, but that's that's why good people know what they're talking about.
Yeah, because I mean, like, it's funny because
lawyers would say no, right? I'm sure lawyers. Oh, he got a discount. Oh no, I'm not going to do it. They're not going to say, oh, what's he charged with though?
Well, the funny thing is, like, as a public defender, it's like you have clients. It's like, oh, I'm not going to resolve this case this way or that way because I want to sue them, and then we're stuck. Like, I was under the impression even sometimes ACDs are bad.
They were.
When was that? That was the same case? The same?
No. That was a Second Circuit opinion, like not the Supreme Court, and they reaffirmed that. Well, it was some gray area. Sometimes, guys, with the law is not really 100% clear. So they message. You know what I mean? I don't know. But the Second Circuit said, hey, we're not going to harm you for ACDs. But before you would have to be worried that an ACD was basically like an ACD, a German and confirmation dismissal. Your case is usually going to be automatically sealed and dismissed within 6 months. And because they said that was kind of an agreement, because you have to say yes to ACD. They can't just force you, even though
it feels like they're forcing you.
Yeah, it feels like they're forcing you, but technically you got to say yes. So because it's an agreement to stipulate to dismiss the case, some courts were saying it's not a favorable termination. And some courts still say it's not a favorable termination depending where you go in the country. So,
So when was this updated?
This was after I left legal aid. So I think around like 2020, 2021.
Okay, so then during a chunk of my practice, ACDs would destroy your case.
Well, they destroy your malicious prosecution case, which a lot of people is all they have. Because a lot of people, they wait for the criminal case to finish before they pursue civil claims.
Now, in state court, let's say I get arrested. I know it's a fucked up situation, but I'm still being prosecuted. If I want to maintain, I probably won't have a good chance of getting a lawyer, but if I want to maintain that false arrest claim, I have to make sure I put a notice of entry within 90 days.
Yeah.
Regardless of how my case is going.
Yeah.
That would preserve it.
Yeah.
And then do I have to file a lawsuit within a year of that, or can I wait until the resolution?
You have to file a lawsuit within a year and 90 days, even the case is still going.
Oh, okay.
To preserve that false arrest claim. The reality is that the false arrest claims, they usually people who are involved in claims, because cases can take 2-3 years.
Yeah.
So most of the time they just, they'll just chalk up the false arrest claim and just file a claim when the case gets dismissed.
Yeah.
But yeah,
I guess
technically you would have to file within a year and 90 days in order to get the state law false arrest.
Are you leaving a lot of like quality claims on the table if you do that? Like I guess what's the value of a false arrest claim like what's the value of having it and not having it? Like what's the
Well, sometimes it's the only claim you have. So, it's a difference between you recovering money and you not. I think that generally speaking, if you got like other types of claims, it's the false arrest claim is just going to kind of go with it. There's certain things like if say you have like it was a bad search, that's what we were talking about, right? And you're screwed on the false arrest claim, even if you had the drugs on you, whatever. There's certain types where it's like, okay, it does hurt certain people. Most people are not. It's not going to hurt, but some people it's going to be the end of the case. They're not going to be able to recover. It's just that simple. Like, like I said, the law's not written to help you. It's not written, for you to understand. So, and again, most people they're not understanding the difference between claim A, claim B, claim C, claim D, claim E. So, they're just going like, let me wait till my case is dismissed, and then I'm gonna get it. And like I said, most people, it's not gonna hurt you. But I will say this: it's you're not gonna get a false arrest claim for a lot of these homicides because their case may last 3 years and your statute of limitations is gone. Even for the false arrest. And I had that in one case the case took 2 years or some change, and by the time I got it,
the criminal case
took 2 years or some change. So by the time I got it, basically the false arrest, all the false arrest claims were gone, but I had the malicious prosecution claim, but because it took so long.
So all right, so back to the original question. Like, so if someone walks through your door, what do they need to be prepared to tell you, and like what are you considering?
Yeah, there's two main types of cases when you analyze them, right? There's one case that has like a victim complainant. I'm gonna use the term interchangeably. I use the term is complainant, but people. They
I'm not complaining.
Yeah. Okay. So I'm telling you what happened. Exactly. So one, there was someone like basically went to the police and someone who did, right? So if someone went to the police, there is a higher standard. It's not even if the person lied, the police are usually going to be covered 90% of the time. So you got there has to be, and I don't want to get too complex, but it's a lot more difficult. Just put it like that.
Because they're relying on the identified citizen complaint.
Exactly. Yeah. Which was presumed reliable and presumed truthful. Yeah. So that means that same thing criminal law. So that means that this person was lying, and also two big things people gotta say about police that they don't understand. One, the police have no duty to investigate.
Right.
So the only reason they would have a duty,
and they don't.
They
exercise.
Yeah. They do what they gotta do, right?
So they don't.
I don't gotta do that shit.
They don't.
There's a limited exception, right?
You want to fight?
If the police are confronted with evidence that they know is like exculpatory, like they can't ignore it. But there's a lot of time. That's why they'll say like, look, this woman said it. I ain't seen, it was completely a lie. I didn't look at it.
Right.
I didn't hear anybody say anything else. It's easier for cops to ignore evidence that clears the person being arrested than it is for them to acknowledge it. Because the more they acknowledge it, it may trigger more work.
Right.
But if they just ignore it and act like it never happened, they're straight. Right? They're protected. All to be protected. So they're saying like they're protected. So they're like, so a lot of times, like I'll tell you something, like if you watch Law and Order and that first person they arrest, that's always in real life that's the person getting charged. There's no further investigation. Right. They're not doing it to realize we got the wrong No. Just go get another one. And they could care less. Right. I talk to a lot of cops. I say, how do you feel about the case being dismissed? How do you care about it? Look, it's not my job. They view it as a district attorney's job to decide who's guilty or innocent.
Which technically it is. Right?
Yeah, well, technically the law says that, if they know that someone probably didn't do the crime, then they have the obligation not to arrest them. They can care less.
Right.
So they don't care whether you did it or not. And not only they get money off it. So every arrest, you get paperwork. You get to do overtime. The overtime is a lot.
Yeah.
And so why would I mess up my overtime by not arresting this person. And again, no cop has ever been punished for a false arrest. I'm sorry, never happened. The only time, maybe they're punished if they kill someone. Maybe. maybe. I would have. Oh, maybe. I would have hold my breath. I would hold my breath. Right. You know what I'm saying? And I can kill someone wrongly, then maybe, but most of the time not. But I'll just say, it also beats you. I get so many cases they send people to the hospital, happens daily, no issues, right? No one cares about that stuff. But and definitely no one cares about putting innocent people in jail. That's just the way the law is. Like, no one cares, you know.
So if there's identified citizen complainant, and it works the same, like you said, in criminal, if someone comes and has identified themselves, says this person did it, that's automatic probable cause. You're gonna now sometimes cops sit there depending on the case and like try to like get the person to like they will give the person a hard time and say, well, do we really want to go through with this? But they're probably gonna arrest you.
They only give you a hard time if they care, though. Like,
well, they sometimes I've had situations where I've made complaints for one thing or the other, and the fucking amount of rigmarole they did to make that case, like to give me a complaint because I needed for like insurance purposes was crazy. Like it was like they were not trying to do anything with that case. But all right, so they have
cops have no duty to enforce the law either. As a Supreme Court. So I know the subway tell you to talk to the cop. I mean they may help you. I'm not saying they won't. I'm just saying they got no duty.
Right.
They
can say no.
They can say no. Yeah. I'm busy on my phone.
Right.
So it's telling me it was like because they want to sue the cops because he filed a complaint, nothing happened. It's like they don't have to do that.
So that guy in that video who was holding the door, police, help, help, police. He was just waiting inside.
Yeah. I mean they could have.
They could have. But 45 minutes upstairs hearing that, and they're like, nah,
it's a little too hot right now. Let me wait 45 minutes.
Yeah.
Cops.
That's the way it's written. You know,
but that's the federal. The states could say, the government could say they have an obligation, they have a duty, but they don't do that. Because again, cops are. Another thing is that cops can be negligent. Cops are held to the lowest standard of anybody in this country. They don't even got to know the law. They can arrest you for the wrong law. Right. It's like good faith, he's trying his best.
Right.
It's like, wow, you trying to
That's crazy.
They got cases where the cop goes a search warrant, goes in the wrong house.
Yeah.
Recovers drugs. He's like, well, he tried. Right. It's like, was the 5A for 5B? How are they supposed to?
Right.
Wow.
That's crazy.
Wow. They say good faith. And good faith is just cops lying. It's like good faith, whatever. Like you try. Like how you? Everyone else, everyone in the world is held to a higher standard than the police. So do not expect too much. That's what I'm saying. Because I know people victims of crimes, and they're the most anti-police people you say because they're useless. Right. Useless. If you really a victim, or someone's gonna come shoot you, they're like, that's not what we don't do that.
No, call us after this.
Yeah, exactly. And even then, we're not gonna if you hop the turnstile, we're gonna come up. We will be there. Yeah. I was thinking about this. I was like, you don't want the TV. You don't see the cops, coming in, saving it. I was like, I've done thousands of cases, criminal, civil rights. I don't know if I've ever seen a case where a cop saved somebody's life.
Right. Pulling out the burning building.
Yeah, like that. Yeah. I don't know if I've ever seen one.
Yeah, damn.
Yeah.
Wow.
I don't know. Have you seen one?
Bro, I work in education.
Like Dave, let me think. Like a domestic violence case
or something. But yeah, like all the DV cases are over.
Yeah.
I just never like to talk about. It's in the midst of it. Like it's going down. Right. It's going down.
Cops.
They had a woman screaming. Yeah, I'm gonna save you, man, like Superman.
I've seen them busting the door when they thought it was a DV, nothing was going on.
Okay.
Yeah. That happens all the time.
Yeah, that happens. That just want to take a real weird. Right. But yeah, I've seen that.
Right.
But it's amazing how much you always hear them breaking it down on the door when it's not happening, but never when it is happening. That's a little crazy.
Yeah. Yeah. No. I'm trying to think. Yeah, because by the time the cops get involved, it's always the situation is kind of like the beginning. It had a beginning, middle, and end, and now someone just has to get arrested. But it's not. It's rarely still happening.
I don't fucking trust the cops.
Yeah, you have to be like, I'm not. I'm just telling you to it's not an anti-cop thing.
Right.
It's
just realize the system
of
what it is, not what you want it to be, what you think it is.
You be anti or pro, it don't make a difference. They're not coming.
Right.
It don't affect nothing.
Right.
All right. So, if there's an identified citizen complainant, does the standard change? Or
Yes.
Okay. So, what are the two different standards?
So the standard technically is the same, but if someone's what they call identified declarant, then it's presumed that there's probable cause.
Okay.
So technically, with a arrest without a warrant, this is the Constitution. I'm not as much the Constitution a lot because it does not apply, but technically,
that's crazy.
If you arrest someone without a warrant, it's presumed unreasonable, and the burden's on them to show it. But that's not how it usually plays out. But I'm just saying technically that's the law. And so when it comes to someone has to identify the declarant, it's presumed that they have probable cause. So you have to show that not that they didn't have probable cause, they have to show that they were confronted with information that would lead a reasonable officer to think that what the person was saying was not true. And again, the most important part is they were confronted with that information. They don't have no duty to investigate. They don't have to look for the information. You could say, if you had just opened up the closet, you would have found out that the knife that I said was there that she had stabbed me with. Well, we don't have to open up the closet. She came to us and said you hit her. That's probable cause.
Yeah, that's probable cause.
So you know what I'm saying? And if you say here there's a knife, she's trying to kill me with a knife. The knife is bloody. It's in the thing right there. Now some courts may look at that and they say, well, maybe they had to, but then they would say, look, people lie all the time. Do we have to investigate every single lie? Now you can say, I walk over there, but again, that's the type of thing that certain judges are going to disagree on, or certain circuits are going to disagree on. That's something that becomes a high risk case for a lawyer, because it's a little bit some people could say yes, some people could say no. The law is not 100% on my side, so most people would say no to that case unless you run in jail for 3 years, and then they'd be like, okay, it's worth it. But most of the time, if that happens, you're 95% of lawyers are going to say no, and the lawyers will say yes. Probably don't know what they're doing.
So for a false arrest case, it's going to come down to whether they have probable cause or not.
Yeah,
right?
and the probable cause is what a reasonable officer under the circumstances would believe that the information that they were presented with would believe that a crime was committed. So that's what probable cause is. And again, so that means every case has its own set of facts.
So what's a common false arrest case? What do you typically see?
So there's two types. So that's type. And then there's other type where there's no, but the cops is a person who says you did something.
Okay.
So that is a lot easier. You said the cop is lying.
Okay.
And that's easy.
Okay.
You know what I'm saying? Because the
cop, fuck you,
yeah.
Why you always lying?
Oh my God.
There's nobody the cop to blame it on.
Yeah.
Right? So it's all about what the cop said. So you say the cop's full of it, and it's a lot easier. So basically, what they'll say, the cop will say, "Oh, I knew this and I knew that and I knew that when I arrested you for drugs or whatever," and they'll be like, "No, you didn't. You just lying." Now it's hard. If somebody else says something, it's hard to say they're lying. Right. But they say, "You say they're lying," and that'll get you far enough in most circuits. That's also not gonna be everywhere. There's the law, and then there's how the law is applied.
Right.
Yeah.
And realistically, and also gotta think I got a small case, considered a small case, 1 or 2 days in jail, judge rules against me, the judge is wrong. I could appeal. Well, how much is an appeal? Right. Okay, maybe 400. Okay. Am I gonna write the appeal? Because I don't know if you ever wrote an appeal before. It's a lot of work. It's a lot of work. So,
Check.
I'm not gonna write the appeal. I'll pay someone to write the appeal.
Right.
Oh, they want 15, 20,000. Cool.
To write an appeal?
A federal court?
Oh, I mean, that's federal. That's feds. That's feds.
It's called a Fed prices, bro.
Right.
It's where
that's crazy.
Fed prices. They not like everybody.
Yesterday's prices.
Yeah, who you think I am?
Right.
federal court, they walk with a little,
Right.
you know, a little box, you know what I'm saying?
They walk like that.
Niggas like, yo, I'm just taking circuit, like,
Oh, what? 15, 20 down, baby. Fuck you mean? You think this is?
that's just a big
I
thing.
golf with these motherfuckers. They better give me a check.
Damn. So I like.
So a lot of times it's like, you know what? I just can't. I could probably win an appeal, but it's just too much money, too much time.
Yeah.
So I gotta let it go.
And most of the cases are contingency based.
Yeah, contingency based. So you
explain
can like,
that
I can't afford to do the appeal.
So explain what that is for the audience.
Yeah, contingency means that you don't pay anything up front. You only get money if you win. Also means your lawyer only gets money if you win.
Right.
Which again, so it's why contingency is a lot of lawyers are I guess stingy. I don't know the way supposed to phrase it, but it's like they're not taking everybody's case. So lawyer has to pay all the money for the case.
Mm-hmm.
Standard fees are going to be filing the case. Federal court is $405. State court to file a case in New York and get the judge involved. To file a case is like $217. To get the judge involved is another $100. In state court, you file a motion, it's like $50. You got to file per motion you file. Yeah, you got to file.
$50?
Is this shit on the menu? You want that big carry on?
We got the all-inclusive option. We'll take care of you. Or, if you're not sure how many motions you're going to file, like the individual motion to file, know that they should say that, certified trial for readiness is going to be $100. The file order to show cause.
This is the state court.
The state court is going to be about $50. So in state court, if you want to file something, you want the court's attention, you gotta pay money. Court says don't come free in state courts. That's everything, right? Mm-hmm. And then you gotta serve them. Process server can be anywhere from like $75 to $150 to serve them. You gotta formally serve them. And then depositions can be anywhere from like $375, $400 to like $2,000, $2,500, depending on how long you go. And all those things are expenses that kind of add up for a case. So a lot of these cases, maybe you get a case, most people write a case, then one day jail, maybe to get $12,000 to $15,000, $20,000, $25,000 if it's good. A lot of clients won't eat, may not get too much if the case goes on too long or it gets too aggressive. And then some lawyers, I'll just be honest, some lawyers, because you can get fees. So some lawyers will just, they're more concerned with getting their fees than they are getting a client the most money. That's not how I work, but
I didn't know about fees. Explain that to me.
So basically, in civil rights cases, there's a code with the fee shifting provision, which means that if you win the case at trial, that means that they can pay. They would have to pay the attorney fees.
And that's state and federal, or just
that's federal.
Federal.
There are no fees. That's good. It's got some good questions. There are no one's ever asked me that. There's no point. No one's ever asked me that. We all point over here. No, because it comes up. Because what happens is I'll be like, because sometimes I'm like, I got it on the state claims. All right, you're not getting fees though. It's like it's like damn. I'm not getting fees. I got them on the state. I got them on the federal claims. But only get fees and you only get fees for the work you do on the federal claim. So if you out here doing, it's like, you did all that work on the state claim, we're not gonna pay for that. We don't pay for the work you do on the federal claim. So they got me again. Got him. Yeah. And but you got it. That a trial's gonna take federal court trial's gonna take about 3 years, give or take a little bit. State court. Good luck. I say by 7 years you should have a trial.
Damn, that's great.
Really?
Because they backed up, or just because that's how they do business?
Well, it's the Bronx.
The Bronx is the Bronx.
The Bronx like to take your blood. No, they're backed up and they're slow and they just get away with it. Everything takes forever. And that's public because you may say you file most. I got into the quickest I've done in terms of down to it. So the way it works is that once your case is done, like done on discovery, done on depositions, you file a certificate of readiness for trial, and you go in the trial calendar. And then about 18 to 24 months later, you may have a trial. Okay? So I got into a trial calendar within 2 years, which is state court, probably earliest you're going to get it. And again, I'm in the 18 to 24 month range. So there's no way that you 4 years is probably realistically the earliest you would get the trial, even if you finish discovery within 2 years. You may not finish discovery for 3-4 years, and then you still got that to at least 2 year wait. And again, that's in like Brooklyn, Queens, Manhattan is gonna be like a year, 12 to 18 months. Bronx is gonna be like, closer to 2 to 3 years.
Well, even if you're on a trial calendar.
That's on the trial calendar.
Damn.
That's on the trial calendar. So you'll see some 2015, 2016 dockets, you know what I'm saying? Cats been out there for a minute. So that's why everybody, people settle, because
why? Yeah, exactly. Why are you gonna wait that long?
It's like you're not, like I could get more money at trial, but you got 3-4 years from now. So I get a lot. Look, I love my clients. They be like, "Why is this case taking so long?" Like, I wish. I don't. Part of it is the system's underfunded. Mm-hmm. Part of it is just that it's it helps the defense side out. It helps the city. It helps all these other people out. And then when you got a city case, you're in the city part. So the city part is the slowest part. If you're in like the commercial part, they actually they put the best judges there because that's people with money.
Right.
But if you if you were in the city, you're in the slowest part. That the judges got thousands of cases. They gotta make decisions on hundreds, if not thousands of motions. So it's going to be a minute. So I don't want to attack the judges because they trying, but they need more judges. They need more. They don't fund it. Right. Why would you fund it if it means that it's going to be worse off for you?
Right.
Because the city's perspective. Yeah, for the city, if we pay more money, then it's like, okay, but then we're going to go to trial and lose.
Why would we grease the wheels if you taking money out of my pocket?
Yeah. Right. Why would it make it easier for you to take from me?
Yeah.
So I'm surprised they fund that shit at all.
Of course.
All right. Before we go to malicious prosecution, because I feel like we're kind of
we'll get to it.
Fleshing out false for arrest. Let's kick it to it. Let's do a little segment transition. So on this episode, as long as you don't know, you want to know. Apropos to civil rights litigations, we're gonna get a little bit deeper on a topic we brought up on one of our previous episodes: the 4 levels of DeBoer, street encounters.
Yes.
Right. So because this factors into civil rights litigations probably all the time.
Yes, it does.
So what I wanted to do is I wanted to discuss the distinctions between level 2 and level 3. So as I explained before, there's 4 levels. There's a level 1, they need objective, credible reason. Level 2, they need founded suspicion. Level 3 is reasonable suspicion. And then level 4, in which you can be arrested, is called probable cause, right? They don't have probable cause, they can't arrest you. That's level 4, right? Now, most cops off jump are going to... No.
3.
They go straight to 3. And the question of whether they are legally at 3 becomes the gist for most suppression issues, right? Because what happens is you get arrested, as Masai was explaining before, there's something called the fruit of the poisonous tree, and when they find out that search or that arrest was in whatever reason illegal, that can suppress the fruits of that situation. So let's say the most common example, they search you, they find a gun, or they search you, they find drugs. Did they search you legally? Right. Did they have the proper amount of suspicion to stop you and frisk you? Stop and frisk. Now, stop and frisk, that is a level 3 behavior. If they don't have reasonable cause to believe that you're involved in a misdemeanor or felony, right? And beyond that, because the distinction of whether they can just stop you or they can also frisk you determines on what they are accusing you of, right? So, for example, let's say, I'm trying to think of a good example, there's a car accident, right? Like a car accident, and you get out the car and you walk away from the situation, and now they're trying to determine that, all right, we're trying to find that person. They give you a description, right? You're walking on the street. The description is a white shirt, shorts, right? There's a lot of people that might fit that description. So you might not necessarily be the person that actually committed that crime. Right. But they have reasonable cause to detain anyone that fits that description, right? So boom, they get the description. They put a bulletin out, you know, over the radio. They see someone with a white shirt and shorts. They can detain that person. Because the crime is not a violent crime, they cannot simultaneously search you at that time.
Okay.
Right? And the reason why they would be detaining you is to attempt to get the what's left over from reasonable cause to probable cause. And they're gonna in that situation, what they would do is they would bring the victim or any witnesses to where they detained you to identify you and do what's called a show up. Which they show up, hey, is that him? And then if they can bridge the gap between reasonable cause and probable cause, they'll arrest you.
Right.
Now, like I was explaining before, is a cop, most cops are going to think they're at reasonable suspicion, and that's going to be the determination.
Reasonable suspicion is looking at you. Like, cops is like, yo, like, I'm there. Yeah. I got it. He's walking down the street. I got it, bro. I'm going to stop him. I got it. Like, they reasonable suspicion.
And the question of whether they have it or not, is that's going to be determined of whether they search you legally or not, right? Like I said, it has to be a violent crime that they're suspected of. They want to search you before they get to the level of probable cause. And the reason why they're allowed to search you if you're accused of a violent crime is because for their own protection. They don't know, given the nature of the accusation, they don't know if you would be willing to harm them to get away from the situation. And that's why they can, for their protection, search you. Now, the big crux, right, is whether they really are at level 3 or are they really at level 1 or 2. Now, most judges, if it's a distinction between 1 or 2, they're going to just give them 2. They're going to say that they're at 2. So now the question becomes, did they do all this at 2 or did they actually get to 3? Now the big law that you want to know, that you don't know you want to know, is that flight from that circumstance, running away, will automatically raise the level of suspicion from a 2 to a 3.
No matter what.
No matter what. Now there are caveats to that. Let's say, for example, and this is rarely going to get a judge to agree to this, but let's say, for example, you don't realize they're cops. They're DTs.
Right.
Best example is they're DTs. They pull up on you and they kind of freak you out and you run.
Right.
In theory, you didn't.
That
wouldn't rise to the level, but that's something you're going to find out. You're going to take that ride.
They're going to say they yell police. Right.
Exactly.
And they're going to say they have their badge out.
Exactly. So it's like.
It's not going to work.
It's not really going to work.
It's not going to work. So I was going to add to that because there's actually a difference, because this from a criminal going from a criminal practice to civil rights, in terms of how the cops express themselves. So they're going to lie in the suppression hearing 100% of the time, but in the civil rights context, they will honestly say, like, yo, because I asked the question, were they under arrest? They'll say, yeah. They were, no handcuffs on, they just stopped them, but they were under arrest. The cop knew, I'm arresting you. But they in the criminal context, they won't say that. Because they know if they say that, then the case is thrown out. Where the civil rights context, again, remember, they're not really going to pay. So in the civil rights context, well, yeah, he was under arrest. They don't care as much. But when it comes to these criminal cases, the cop, this is why you get some crazy stories in criminal, because they're manufacturing a story that's going to beat suppression. Exactly. So they got to make every step that has to be, this person did this, and then I did this. I yelled police, and then I yelled stop. And when after I yelled police and I yelled stop, then he took off running. And after he yelled police and after he yelled stop, he took off running. Then I proceeded after him. And then when he proceeded after him, I saw him toss an object into the trash can. And that object, when I was able to look into that trash can, I saw this object was a gun. Now, and that may be true sometimes, but most, it could just be some guy ran away and they found a gun in the street. Mm-hmm. And they're like, I don't know what's going to got here, but I'm just going to say the story out. And then this black kid was running, so I'm just going to arrest him and, make my life easier.
If the DNA on it, then they get him. If it's not, they set him free. Or a case like that, the DNA is not on the gun, and they still prosecute him, and the jury throws out everything, and that's when you may have a civil rights lawsuit. These guys are crazy. You imagine you get cops and you got a gun, DNA comes back, you're excluded. No, those excluded means that there's no way you touch this gun. They're gonna prosecute you anyway. But cops, the story didn't hold up. Most of the time, though, they'll throw out the case. Cops know this is overtime. Everybody wins. I mean, except for the victim. The person who spent X amount of time in jail.
At founded suspicion, the distinction, like I said, reasonable founded. And if you run, you're raising it. And that's what you kind of don't want to do. Now look, in the days in which cops didn't have body cameras, if you really got something on you, is it the advantageous choice is to book it? Probably. But in days in which there are now body cameras, right, you have a much stronger ability to fight any charges that potentially get produced from a search, regardless of what they recover, right? Because at level 2, they can ask you if they can search you, you can decline. They can ask you for your ID, you can decline, right? At level 2. Because they have suspicion that you might be involved, but they're still in an investigative state. They haven't reached the level that you're the guy. Mm-hmm. They might just say, "Hey, where are you coming from? Like, did you come from the direction of the crime? Oh, I'm coming from I live right here. I'm coming from my mom's house." That's going to lower their level of suspicion in theory. In theory,
if you say no to anything,
you're the one.
You're a criminal. You did something wrong. You're gonna find out what it is. You know what I mean?
I mean, this becomes more prevalent in the age of body cameras because these cases now are going to be a live or die based on what these body cameras capture.
Some bad searches on the body cam.
Yeah.
They like, because a lot of the time the lies don't hold up as well on body cam.
Exactly.
When I asked this, I said that, like, you know what I'm saying? I got one case I just settled. The guy, it was this whole story about him drinking a bottle in the middle of the seat, because he went up to they went up to a parked car and they asked what you're doing. So they said they saw a bottle. First off, the body cam comes out. There's no bottle in the car. You see, the guy searched the whole car. Didn't find one bottle. They asked him why I'm being arrested at the scene. He says being arrested for weed. Right? Nothing to do. So this whole thing is that I approached him, I did stuff because of a bottle. The body cam says no. So this is a DP, right? This means they declined to prosecute. But my thing is like, the DA's office is what I mean when they cover. It's not, they made this lie. You got the video. Why are you not prosecuting the cop? Why are you not asking for discipline? Right? Because no one cares. At the end of the day, guess what? He got his overtime. And who's paying for it? The taxpayers pay for the settlement.
And beyond that, let's say, for example, let's say you don't have a gun. Let's say you don't have any drugs on you. But then you run, right? They at level 3, right? They've risen. Now they can chase you. Now they can tackle you. Now they can arrest you, right? And it becomes a weird thing because they're running after you to see if you're the one that committed this crime. They're running after you for whatever, to see if you have anything on you. You don't have anything on you, but the pure running, the pure interaction you have now because you ran and they they tackle you and they fucking stub their pinky, you just get charged with assault on a police officer.
Assault 2.
Any assault 2, because any assault on a police officer is automatically a D felony. So anything happens in this arrest in which a cop gets injured, they look, not to be conspiracy theorists, but it's going to be in their, they are going to officially claim that injury so they can get time off.
Right.
Because if they don't,
I'll be the conspiracy theorist. They're gonna lie. They're gonna lie, and they're gonna get time off. The pinky toe and the pinky stub is one of the most serious police injuries that you may. It will automatically require hospitalization and automatic times off. You're lucky you don't get workers' comp. This cop who sacrificed himself for the city needs to be properly compensated for the suffering that he did. And tackling this black.
They got good.
They got good union, bro. That's crazy.
Yes,
they'll punch you in the face and be like, "Bro, my wrist is messed up."
Like, your face is so hard.
Like no one told this Negro to have such a hard face. Like they got. Somebody gotta can't be somebody, bro.
Like assault on a police officer, which is really just
they love that in Queens too.
Right?
I see the assault 2 in Queens. I'm like, these Queens officers are just wilding right now with the assault 2.
You'll easily get a discount for something like that because the prosecutor kind of knows, this is a bullshit.
And it's so crazy. Let me tell you how crazy it is. If a cop says that you assaulted him and they give you a disorderly conduct, which is not even a crime, that the DA knows this is full of shit. And the problem is, again, we're talking about the system. The DA knows, the DA would never give out, especially in Queens, right? The DA would never give out a 240-20 disorderly conduct, which is not a crime, for someone who actually assaulted a police officer. They take that very seriously.
Right.
Most people take it very seriously. Queens, Staten Island are some of the most conservative jurisdictions. They're going to take they're taking it more seriously. Okay. So they know this is bullshit. But instead of just doing the right thing for something that's bullshit, They say, well, we're still going to make you pay the $120 and we're still going to put it to $240. Why? Covers the cop. Let me tell you something. There's no way you have a civil rights lawsuit for excessive force if you plead guilty to disorderly conduct. Because they were saying you were acting disorderly, right? You were.
So in response to whatever you were
doing, it was reasonable. Because again, it's based on what you were doing. So there's normal behavior and there's disorderly behavior, and you were acting above the norm. You were acting disorderly so much that you could have spent 15 days in jail for your conduct. That's how egregious your disorderly conduct was. So there's no recovery. Now maybe recovery for, like I said, the malicious prosecution, false arrest, but nothing for excessive force. So I'm like, you gotta understand, these DA's offices are covering for the cops, and they're making my job difficult.
They're not gonna make it easy.
You know what I'm saying? But people don't realize that, the DA is trying to F up your right to sue.
Right.
The DA is trying to make sure you get no money off this case.
Right.
People don't know that.
Right.
They're making you take dumbass pleas strictly, and again, I don't blame the lawyers. You charge them assault too, you get 240-20, you gotta take it. Let's be honest here. Because again, you know the cop is lying, the blue wall is gonna come up and everyone's gonna say this is what happens, right? So you gotta take it. But the DA's office is out here doing this on purpose to make sure you get no money. Right? Because they're invested in the system of depriving people of their civil rights. And that's what this system does. Anytime you make someone take a disorderly conduct on a claim that you know has no merit, the only reason to do that is to make sure that they can't recover damages for the police officer lying. Because assault is a serious crime. It's a felony on a police officer. Okay, so if a judge sees assault too, they're going to take this very seriously, right? So you may actually have some real damage. You may spend some real time in jail. It may have affected your life. You may have lost your job, and all this stuff may have happened. So they're like, we're going to make sure you get no money off of it.
Okay, so I've seen Twitter is always a lie. They're always lying and stuff like that. And I've heard other people have said that sometimes trying to punish police officers or get compensation, that instead of doing it through the city, you try to sue the insurance company that insures the police officers, which is a private company. Now, I want to know, is that so bullshit?
The city are self-insured.
Self-insured. So the government insures themselves.
So when you sue the city, you're suing the insurer.
Okay.
Because they insure themselves.
Right. And that's in every state?
No. It's different. It's big. So they may have insurers. The way insurance coverage works is that they're probably going to pay for it. Insurance agreements have different things that they cover. If you're going to insure a police precinct, you're probably going to cover police misconduct. Mm-hmm. So the insurance company is going to pay for it. So it's not really, it's a distinction without a difference. If I sue the officer, if insurance comes in, that means that the insurance company pays.
Right.
The issue again in a lot of smaller places is that they'll fight you to death for I don't think people understand, like, every case is going to trial.
Mm-hmm. And when you say small, you mean like small towns?
Yeah, small towns and stuff like that. They're every case is going to trial. And so what that means is, as a lawyer, that means, because they're not going to settle,
mm-hmm.
and so that means that you get every case you got to put out lots of money,
mm-hmm.
every case you got to put out lots of time, every case you got to put out lots of energy, and again, the award may not be a super lot depending on it. So they're just the way they deter lawsuits is by just, even when they know the cop is wrong, just like fighting you forever, right? Mm-hmm. And that means you can't bring as many cases because you can't fight every single case to trial. No one has the resources to do that, and it's just not. As a business model, it's just not going. You're not going to make enough money to keep your practice, because again, that means you're not getting paid. So that means if I take every case takes 3 years to go to trial, from the first case I take, I need 3 years of capital to go for the fact that I haven't made any money. Mm-hmm. It's in every case. So that
and it has to be able to cover the 3 years. So
I
need 6 years.
Yeah, exactly. Yeah. You really need 6 years.
Yeah,
and that's assuming that you don't have especially if you don't know about anything. So
Right.
you that's if you go in the game, if you start to work, you wouldn't need that much. A lot of firms, it's just not worth it. Because because even if you win, most civil rights cases, the damages are going to be 5-figure, low 5s to mid 5s. So if I win the case after 3 years of work, I get like 25,000, then 1/3 of 25,000.
No.
So yeah, you gotta understand the business side
How much
of it.
motherfuckers spend on coffee?
So like, what? 1/3 to 10 G's? People spend 10 G's in 3 years. So a lot of local governments, that's the way that it's pretty effective. And you wanna look. Most civil rights lawyers are gonna be liberal, which means that they like cities. They like hanging around big cities. You're not. I'm just
finding in the sticks.
Bubble fucking. I know. I say it's so funny because I'll say this because a lot of people don't realize. I'll say this. There's a benefit of being black. Black people have a lot more access to civil rights lawyers than white people do because most of this country, there's nobody. Nobody. Wow. You go who swaths of this country. There's no one who's going to do a civil rights case.
Wow, really?
Or there's maybe one person for the entire
middle of the country.
Yeah, exactly.
45 states.
The civil rights lawyers, you got a lot in Cali.
Right.
You got a lot in New York.
Right.
You know what I'm saying? You got a lot. You got a lot in Atlanta. You got the places that the lawyers want to live, and you're gonna have lots of but Milwaukee.
Yeah.
Ohio. Shout out to Milwaukee. I want everybody nice cheese curds out there. Listen, I'm screaming the bees. The data. Like it tells me. I don't tell it. I in Indiana trying to Oklahoma. I don't know. Why am I here, bro? It's like a latte. Can I get an We're in the hills.
Have you done cases out of the Second Circuit?
No, I'm not practicing outside of Second Circuit, so I'm not. I've done cases out of New York City, but I'm not admitted outside of Second Circuit.
Federally, you're admitted based on the circuit.
Yeah, we got Second Circuit separately, but you basically admitted based on the district.
Oh, that's what I meant.
Yeah, by the district. So I'm Southern Eastern District, which is going to be Bronx to upstate, all the way to Albany. Going north from Manhattan, and then it's going to be Staten Island, Queens, Suffolk, and Nassau counties.
Oh wow.
Like I said, places, but I think I don't know how accurate this is, but my friend was telling me that he was looking up civil rights cases in Houston, and it was like only like 2 firms out there that were seriously doing civil rights litigation. Houston's one of the 3rd or 4th biggest cities in the country. And what happens is when we got the 5th Circuit out here,
good.
Lawyers don't want to do it. No lawyer wants to spend all this money on energy on the case because it's a contingency cases. So like, I gotta have a case that I know is going to win. So can you have a civil rights practice in Texas, knowing that you're going to lose a good amount of your cases? Probably not. You gotta have that person. Like you do some civil rights cases, right? But a practice.
Not totally specific.
Yeah.
Specializing.
Probably not because it's too hard. And also like Texas has a cap. The state claims have a cap on damages. The federal claims.
That's crazy.
The federal claims.
Cap on
damages. And the federal claims you're going to the 5th Circuit. So it's just like, look, man, I'll take it. I'll take some claims. You can always take some civil rights claims, but can you do a practice out there? It's tough. It's tough to do a practice in these states, in these jurisdictions where they're hostile to you on the state level, and the federal level they're also very hostile, so it's difficult.
All right. So moving on to malicious prosecution. What makes a case like it's just a favorable disposition, or what about the actual prosecution of the case makes it malicious as compared to not?
Yeah, so people are gonna kill me about maliciousness because malice is an element of malicious prosecution. Malice can be inferred upon with lack of probable cause. Okay, so if you arrest someone without probable cause, you can infer that that's malice. That's good enough for pleading. For trial, it may make a little bit of a difference. But basically saying that it's all the elements of false arrest except you had a favorable termination, meaning the case was dismissed. So So if for a false arrest claim, like you said, you don't have, doesn't matter whether you were guilty or not. For a malicious prosecution claim, it doesn't matter whether you were guilty. It doesn't matter whether you committed the crime. If you committed the crime, even if your case is dismissed and you committed the crime, you're tough. It's tough. It's a tough sell.
So shit, like a lot of cases get dismissed, especially due to the new discovery laws. If your case gets dismissed, does it automatically have a value as a malicious prosecution case?
It could, but
Depending on what?
well, you have a favorable termination, so it's dismissed. The question is like, well, did you do it or not? Because if they dismiss, like you said, for discovery, they still have probable cause. It doesn't matter. You don't have a claim, right? You can't. You know, like I said, if someone comes to me like I was arrested, my case was dismissed, I'll take a look at it. You know, but the reality is that if they had probable cause at arrest or they got probable cause later, it's nothing about malicious prosecution, is that they can get at any point in the prosecution they can get probable cause.
So you have a girlfriend makes false accusation and you assaulted them. It's bullshit. They don't want to cooperate with the prosecution. They don't pick up the phone. Case gets dismissed. That might not be considered malicious prosecution.
Well, it could. No, wait, no. Let me correct myself. It's not because you got probable cause. And also, a lot of malicious prosecution, again, malicious prosecution only really has value if your case went on for years or you spent a lot of time in jail. So that in that instance, you know, that person gets ROR because of misdemeanor in New York. They get released on reconnaissance. That means the only claim for damages is really going to be the false arrest claim because they only went to court 2-3 times. You got to go to court at least probably like 3 times to get a malicious prosecution claim if you're out. And then if you're, and even then, you gotta show damages. You gotta like lose your job or something like that. If you're just unemployed, you gotta go to court. I mean, there's no money in that.
But I remember I had a case which, like, rarely do I tell my clients, like, you should sue. You should sue. This is crazy. But I had a case, this dumbass case. It was a aggravated harassment case, right? In which they're in a parking lot, right?
Aggravated harassment.
And this old dude is accused of telling the complainant to drop dead. So I argue at arraignments. I'm like CPL 145.45, which is 140.45, which is basically on its face they have not made out the charges because telling someone to drop dead is not a threat. It's not a threat that.
A threat has immediacy. Immediacy of you carrying it out.
Exactly.
So
I'm gonna kill you.
I'm gonna kill you, and you have to be reasonable to think.
Well, I'm gonna kill you tomorrow.
That's not threat.
Tomorrow would not be immediate.
That would not be immediate.
I'll kill you if it becomes an if statement, then it's not immediate because it's saying like, if you fuck my sister, I'm gonna kill you.
Right.
You gotta fuck my sister first.
Once you fuck the sister, then I'll be on alert. You know what I didn't think she getting up like that. I'm sorry, bro. You better watch out. Right. The if it becomes a promise.
Right. So it was like they got into an argument and he told him drop dead, like kill yourself, basically. So I argued that at arraignments, like, yo, this is on its face. In theory, which just you never get a judge to agree. If you make the argument of CPL 140.45,
that's pretty bad though. Drop dead is aggravated arrest. That's pretty bad.
So if you make that argument at arraignments, in theory, the case should be dismissed right there because the argument you're making to the judge is that you don't have jurisdiction over my client because it's almost like they charge you with assault, but the words of the complaint don't say you assaulted them. Right. It says you curse at them, so it's not assault. Then that you don't have jurisdiction for that claim because they haven't made it out on its face. Right. That's a very low bar. It's like you just accuse them of what you're accusing them of. Right. The judge agrees, but is not willing to dismiss it, and says, "Hey, you guys gotta rewrite this. Rewrite this. Have it rewritten on the next court date." The next court date, these motherfuckers change it to disorderly conduct because they say that he was causing that he was rambunctious and he's causing a scene in these statements. But I'm reading the complaint, but man, this is in a parking lot. There are no other people. Disorderly conduct requires like you have to
Scene.
you have to call.
Try to cause a scene.
Yes, like
Right.
you can't have disorderly conduct in a vacuum. If it's just me and you in an apartment building, it's not disorderly conduct because you have to.
Even if we're arguing, you gotta like try to draw a crowd in.
Right.
Exactly. So it's like, how are you changing this? Now you get into the level of malicious prosecution because you guys are so thirsty to keep this case
Right.
that you guys are making up charges that don't even. That,
Oh,
you double down on your stupidity.
Right.
So that's a good point. So the question becomes, who do you sue? It's another good point. You pay attention. So federal claims. Big difference between federal and state. Federal claims, you sue the individual officer in an individual capacity. And besides, I don't understand what that means. Look, knowing you're not supposed to. The point is this. The officer, like Bob, I sue Bob Johnson. Bob Johnson falsely arrested me. Then I'm suing Bob Johnson. Am I suing the NYPD? No. Am I suing the city of New York? No. I'm suing Bob Johnson. Bob Johnson is in Bob Johnson, which means technically, if the city is to come in, I'm going after Bob Johnson's property.
Yeah.
I'm going after Bob Johnson.
He got a nice brown
Bob, what you got? Bob got a BMW. Right. Bob's BMW is my BMW. Bob falsely arrested me. But the reality is, it never happens, right? Mm-hmm. But again, it protects them. So say they get a cop who does something wild, like, I went out and I killed 3 people by accident, right? You'd be like, this dude's wild. We're on the hook for like $7-8 million. We're gonna drop him.
That's what happened.
We're gonna drop him. We're not covering him. So he's like, he killed me. I got 3 wrongful death cases. Look at that, $20-30 million. You get nothing. Why? All you get is that cop's assets. What he got?
Nothing.
And a lot of times, and he was smart like Amber Guyger. What she do? Sell my house to my mom.
Right.
You know what I'm saying?
Right.
I got no property in my name.
Right.
You know what I'm saying? So
Do they do that often? I feel like.
do they cut the cops?
Yeah.
If it's something
about
that's really
money.
bad,
Yeah.
and they don't want to cover it, they'll cut them. Like
You
something like a
know,
rape, like I think those cops in New York, they raped someone who was in custody.
Right. Yeah. I remember that story.
They dropped them.
Mm-hmm.
And because in federal, you're suing them directly, you don't have a claim against their employer, the NYPD?
So
Federally?
no, you don't. Now state law, you do. State law, you have what they call responding act, which means that if you're working within your course of employment, you commit the acts as your employer is responsible. The federal courts have rejected that claim. Now there is a claim called Monell. And Monell means that you have a pattern or practice of unconstitutional activity in your jurisdiction that the city knows about and that they allow to happen. Now because you have this pattern and practice, that means that my individual person was harmed because you did not do what was necessary to stop it. But that's a whole separate claim, and
That also requires
A lot.
you finding that trail, like that
Yeah.
cop has to have a record.
So a lot of times, so they, even you go back to the Bob Gene Amber Guyger thing, they try to claim that there was a pattern of excessive force in to get the city responsible, but the court rejected that. It's hard. You got again. I could probably plead the one, and I'm actually going to plead the one now claim about excessive force in the New York Police Department. I can plead it, but the reality also is that what they do is what they call bifurcate the trial. So that means that they'll say, okay, you have a person who you say was harmed by the police, and you have this Monell claim saying this is caused by the police department ignoring these type of claims. All right, you have to win a jury trial on saying that his rights were violated. Once you win the jury trial, we'll let you get to the other claim.
Oh, wow.
Wow.
So you're not even going to any discovery. You're not going to touch the claim until you win in a jury trial.
And these claims do have a shelf life, right? They have a.
Well, and all claims have 3 years.
Once you start it, that 3-year period. It's not like you have to. It's not your fault the case is taking long.
It's not like you have to figure.
No.
Once you file a claim, you've done your due diligence to keep the case alive.
Oh, then that's when the clock starts.
Yeah, but if you think about it, it's going to take you 3 years to get the trial. You have to win the trial, and then you're going to get to the Monell discovery. And that's not always happen. It happens a lot. I just have a Rikers case where they moved for bifurcation of discovery, and it was granted. So it's basically the same situation. I had to prove that my client, had his constitutional rights violated, and then they'll give me the other stuff. But until I prove that, they're not going to give it to me. And so, that's just the reality of it. So it makes it a lot harder to get these big claims against the city for doing complex things because of you have to prove your guy was harmed first. They're not going to give you that discovery.
So I feel like we're covering the two big ones: false arrest and malicious prosecution. Is there another claim that's very common for civil rights litigation?
Well, yeah. So the due process claims. So Brady and fabrication of evidence. So what's the difference? So fabrication of evidence does require favorable termination as well. And fabrication of evidence is when an officer lies. Actually, that was wrong. Favorable termination does not require favorable termination. I was right. I was wrong. Listen to that. Take it. So fabrication evidence does not require favorable termination, which is why some people may like that instead of malicious prosecution. And it basically says that because the cop lied or said something over, you were in jail for longer than you would have been. It also implies coerced confessions and things like that. It's a good backup plan. You could believe that there was probable cause for arrest. You could believe that there was probable cause for the malicious prosecution, and you could also believe the cop lied and put the evidence to the district attorney, and that caused harm to my client. So now that even though there was probable cause, the probable cause is not a factor in fabrication evidence, which is important because now we're just talking about whether the cop lied about something and forwarded it. If it doesn't, I don't have to worry about these other standards. Same thing with Brady stuff, where it's if I knew that was exculpatory and I didn't forward it, then I can say hey, if he gave this information to the DA would have. I'm laughing because they wouldn't, but. No, anyway. I gotta say with a straight face. If you had forwarded this information to the DA, what they would have done is dismiss the case. Right? Yeah. They ain't doing that. They institute for you. I remember, I had a robbery case, right? And the guy went in, was arrested. My client was arrested. He went in and he said, look, I didn't commit the robbery. I know who committed the robbery. This is who committed the robbery. And then the person that was a cross-racial ID, which if you know are circumspect. Yeah. But a lot of it was that the guy said the guy who robbed him was 5'7". My client was 6'2".
That's
right.
Huge fucking difference.
Huge difference.
That's disrespectful.
Guess what? I was sick. I was able to find out because the guy had been arrested for it. I was able to find out because they got his bio. Guess what? The guy he mentioned was 5'7", right? So we're in the middle of this robbery, and they're like, all right, they know the case is complete BS. And they're like, look, we'll do fortune, and we'll dismiss the case. And I'm just like, well, he didn't do it. And it's like, well, look, I can't dismiss it, because the supervisor says no, you can't dismiss it. You can't dismiss it. So we can do fortune. So basically, he does a bullshit program, and they dismiss the case. Now again, fortune is bullshit. Fortune is a great program. but
being fortunate,
delete the fortune is bullshit. I like fortune, right? But the reality is that this guy, the problem is if he goes down minimum 5 years. Nothing you can do about that. Goes down to minimum 5 years. And the cops, the case was resolved after I left the office. The supervisor I trust a lot was like, look, the guy's horrible testifying. I was like, all right, it is what it is. You gotta rob one, dismiss. Right. Because he used a knife, and it was supposed to rob 525, first time offender. But we're talking about the guy didn't do it. Everyone knows the guy didn't do it, but it's too much work. Yeah. It's too much work to find the guy who did it. Everyone, so we just let him plea out. So that is marked as a solved crime, and that is marked as a person who did it. Crazy. And it's everybody knows they do it. They're not going to give you a dismissal after 6 months. Basically, the ACD on a rob one if they think you did it.
Fact.
There's no a rob one. That means you took a weapon, pointed that weapon at someone, told them to give you your money or I will hurt you. They gave you the money, you took it, and you ran. And they're saying,
oh, wow, hunt.
Give me your money. They're like,
Give me your money.
They're like, hey, we'll just give me 6 months, we'll just throw it out. Right? Like, what? No, of course not, bro. They know it was BS. But look, you know, no judges. They will dismiss the deal, do the right thing in pleadings.
Okay. All right. So I guess I feel like we can close it off on how do you determine, or what is there a metric to evaluating the cases? I mean, unfortunately, the more jail time, the better, right?
Yes. Yes. So, I'm going to jump this. Please don't attack me when I use these terms, but there's a market rate for incarceration, and there's a value that goes on it. And I'm not going to say the value. Because some people are going to get very upset, some people will be very happy, but there's a market in terms of
what's that number?
What's that number? No, the number can vary. It varies on.
Give us a range.
Anywhere for how long?
What's a day's worth?
A day's worth, if they work anywhere from 2,500 to around 30,000.
Okay.
Without any injuries or anything else.
Okay, and is every day compounding that number, or is it now? Okay,
so your value goes down every day. So there's some factors that are going to factor in. 2, 1, how good your lawyer is, right?
We got
Like, let's be honest here, all right? So, like, they will, because they do it to me, they'll be like 2,500, 1,500. Okay. A lot of lawyers will say yes. Okay. And then that's the case. Because they don't know what you can get. But the other factors are like whether you've been incarcerated before, whether you have a criminal record, and then there's soft factors, like women generally going to get more than men. You know, unfortunately, like, you know, they're going to offer more for non-black people and then, you know, the black people.
What?
I didn't say that, but it's true. And again, I want to be very clear. Like, I don't support any of this, right? I'm just letting you know.
But it is what it is. The data tells you. I don't tell you.
These are the facts.
The fact.
Right.
Certain groups are going to get
You
more
want me
money
to
than
say
other
something
groups.
different? Get the data to tell me something different.
Like, you just got to be aware of it because you know these are things that are real. Like again, I don't make the system, and I do work in the system, so you can tap me for that. But the reality is that you know when you talk about offers of different types of clients, certain clients are going to get more money for the same misconduct than other clients.
So what's the tipping point to get big numbers? How many days in jail? What's the perfect number of days to be in jail falsely?
I want to know something that happens to me. I'm like, you know what? Now I'm good. You'll take your time. Like 6 is magic. 6 days.
I think
magic number.
The more you're going to get more money in jail if you can, like, I think it was a doctor who spent like 8 to 10 hours and got like $40,000 something like that, right?
Oh, because you wasted my time.
Because he's a doctor, right? You know what I'm saying? Like, it's just, you know.
Oh,
so occupation also to
well, what you're missing. See, if you can say like, look, I have a high value job. You know,
well, like some Wall Street guy. I could have made the country.
Yeah,
I could have made $100 million.
Exactly. You can allege damages even for a small time of arrest.
Damn, I gotta stop being a teacher.
But if you ain't getting the daily rate though.
What is it? The minimum wage.
Divide that by like your 300.
Right. So you said one day anywhere from 2,000 to 30,000
in New York.
In New York,
it varies by
now. Like, what is like 30 days worth? Give me the standard: 10 days, 30 days, 3 months.
Okay, all right. So when you start talking about longer incarceration, it does there's some factors that are very important. One of the most important factors is going to be, your experience with the criminal justice system.
Meaning,
if you've done a significant amount of time, the value of your incarceration goes down significantly.
Wow, really?
So basically, when it comes to
the
law says, so you don't attack me. The law says that when you are able to determine damages you can look at someone's incarceration history. And the argument there is that if you've experienced it before, it's not as bad the second time. I did not say that. You gotta quote me on that. They don't give a fuck, yo. That is crazy. That is not me saying that.
Oh my God.
I do not believe that.
Shut up. Sit down.
I do not believe that.
You got a bed. Relax.
You dropped the soap. Shut up.
You ain't gonna start the polio.
Yeah, so it's messed up. So a lot of clients, good people, you know, they're very upset because they think they should get more. They probably should get more, but and part of the problem is the jury's going to hear that. Mm-hmm. So that would mean that the jury would hear that you've been. Well, first of all, it may get into those two phases to a civil trial: damages and liability. And there are some rules in terms of damages, in terms of liability, in terms of whether certain offenses can be admitted into evidence. But when it comes to liability, it's a little bit more of a question. They're going to say, hey, look, you went to jail, you spent some time incarcerated. That means that this current incarceration is not severe for you because you spent 2 years, you want to stay for 2 years. And the jury's going to hear you want to stay for 2 years. And that also is going to, realistically affect the jury. Now the jury will come back because they'll be like, oh, this guy's going to be the felon versus somebody else. So a lot of people a lot of clients I deal with get very upset about this. And I understand. I want to be clear that I'm empathetic and sympathetic. I didn't make the law, but this is the law, right? And so it does matter. And so you talk about 30 days. I would look at 30 days. Like I said, a small. The New York is a little bit higher than the jurisdictions. Anywhere from 20,000 to 120,000, something like that. 30 days. 30 days, depending on who you are, maybe more. The upper range, if you got a real nice gig, you could be. But most people who got nice gigs aren't spending 30 days in jail because they're gonna bail out. So you know what I'm saying? But if you got 30 days, I would say 30 days. A reasonable result is with no record. Between 50 and 90,000.
Okay, so what kind of price cut you getting if you're a felon? How much less is your time worth?
It depends. Are you what type of felon are you? Are you a felon that was a very long time ago? Are you a felon who just got out last year? Are you a felon who's convicted of sex crimes? Were you a felon who committed of violent crimes? Are you a felon who's done lots of misdemeanors since they got out? Are you a felon who works and has a job? In that regard, there is a little bit of wiggle room in terms of and I've made these arguments. I've had some clients of mine, are very good people, convicted felons, and I'll say, look, the man's working, he's a working guy, he's doing a job, he's providing for his family, and he, he's doing the right thing, and that does play a good influence. But if you're a convicted felon and you back out doing what other stuff that got you in, I got some guy, spent a long time in jail, but he's a young guy. He's out here. He got a couple gun cases and he got a couple more after he got out. And he was kind of gangbanging before he's gangbanging after. I think he's a good kid, personally, but you're talking about a huge. When they start finding that stuff out, there's we're just not, because we're not afraid to go in front of a jury when it comes to someone who's been, you were convicted of having a gun in 2019, and you were convicted of having a gun in 2022, and then you were convicted of having a gun in 2024, and
So forgive me if we got it wrong.
Exactly. Everybody makes mistakes. It's like they're just not going. And then, from a lawyer's perspective, it's like it becomes tough because it's kind of like they're right. Like you could put this criminal history in, and they say you're not doing anything.
Right. And then you're just wasting your time.
And, it's like, again, you don't know. Some people will look at criminal history different than other people, but there are certain people who will hear criminal history And they'll be like, okay.
He did it.
The first time someone say he did it, so be like, yo, they give him $1,000.
Right.
Give him $500.
Yeah.
You
Give
know?
him coffee. Right?
Yeah. You know,
you want Starbucks? We'll get you Starbucks.
yeah.
All right.
So, and those, and again, it's what makes us, you know, it's tough to have this conversation with you because, you know, I'm not the type of person who holds people pass against them. But the reality is the system does.
Right.
So you gotta understand, like, if you're, it's always good, I would say, it's always good for you to try to do something positive with your life, to try to turn around because the system will, that's gonna get you, if something does happen to you, the system's gonna look at it and give you more money, you know, versus someone who's, you know, still out doing the same shit they were doing.
Your civil rights are worth more if you being civil. All right, well, look, man. Thank you for coming.
Word.
I understand why you're in the top 5%. I feel like we could be here all day, but you know, we could do another episode. Let them digest this one.
Right. You know, I appreciate. Look, you know, and I want to say that, like, you know, because a lot of people, when you describe how the system is, I just want to be clear. A lot of people feel like you're endorsing it, and I want to be clear that. This is not a system I would create. You know what I'm saying? But my job is to teach, help you, and not for having to teach you, but also to help you navigate the system.
Right.
Because what I do is I have a specialized set of knowledge, and that enables me to know how things are going to deal. And I'm going to tell you the truth, and I'm not going to gaslight you or whatever. And a lot of these people call themselves liberals, feeding on bullshit, you know, about what's really going on, what's really going to happen. And a lot of people claim to be liberal, the same people I got to fight every day to get you some cash.
Right.
So, you know, screw those people. You know, it's like
Heard that?
Yeah.
Yeah, you too. Hey, the motherfucker behind you, fuck that motherfucker too, bro. I see you, bro. Nigga, I'm seeing you. I'm looking right at you.
It's crazy. Cause I'm gonna say this with my soapbox. My soapbox is a little thing. It's like, you wish it would be, I did something wrong, you are harmed by it, therefore you deserve something. That's not how the system works. Right? And when an individual does something wrong, you're going to be held accountable. When they do something wrong, they're not.
No.
And I can only try to get you some money. I can't control the system. So you guys got to vote, participate in politics. You know, it's tough. You got to. It's tough because you don't know who to trust. But maybe I'll get involved in that a little later. So you can know who really like your side eye here, who's gaslighting.
Right.
You can these guys, man. You cannot trust these people, man.
Right.
You know, but you know, I love everybody.
All right. Well, before we bounce, tell them where they can find you. Social media, website.
Yeah. So you can find me at Lord Law Group PLLC. You can find me at nycivilrights.nyc or lordlawgroup.com. You can find my number 718-701-1005.
Woo!
You can find me.
Gonna be busy.
You can find me. You can send me an email if you need info@lordlawgroup.com. That's one word. I'm always here to help.
Thank you for coming.
Yes.
We're gonna have you on a future episode when we dive a little bit deeper into the nuances of each case.
Yeah.
We already covered a lot.
Yeah, no, we covered a lot. This is good. Let me tell you something. You don't get this information anywhere else, man.
Right.
Because everyone here is just trying to. I'm what they call a grinder. You know, I'm deep in the system, bro. I'm used to these 1 day in jail cases, fighting every day, doing motions every day. A lot of these cats, they work for these nonprofits. They got 3 cases a year they're working on. You know, working like 100 cases. Like, come on, man. It's not the same. So, like, I know how to navigate the system, and I don't lose. So, you know, you can take that to the bank as well. Whew, facts.
Hey, what's up?
If you like what you're seeing, like, comment, tell us any ideas for future episodes. Make sure you subscribe, make sure you share, and check out our merch shop. We out of here.
Seen it coming like a prophecy, cause the work got us moving with velocity. We beastin' now, it's some monstrosity. We the plug to the source, unshockingly. Wow, what's he really gonna do now? Jolts in your system better stay on the ground. Votes in the circus is a spark to the sound. The energy that entered me are jewels in my crown. Wow, that's how it's always gonna be. You'll never really get it like NRG. Could do without the static and the flattery. Chill for I catch a charge like battery.
No style, what? Turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No style, what? Turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Turn your energy up. No style, turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Turn your energy up. No style, turn your energy up. No work, what? Turn your energy up. Too wild, turn your energy up. Turn your energy up. Turn your energy up. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy, just energy. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy, just energy. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy, just energy.